This is an overview of civil cases presented by the Community Legal Education Association. This is general information only, not specific advice. For legal advice on your specific situation, talk to a lawyer. Civil cases are dealt with in the Court of Queen's Bench. Administrative tribunals deal with certain civil matters. For example, the Residential Tenancies Branch and Commission deal with disputes between residential landlords and tenants, and the Appeals Commission deals with appeals of workers' compensation matters. Cases involving amounts up to $15,000 may be heard in small claims court. However, small claims court cannot deal with the following: disputes between residential landlords and tenants, disputes about land, claims of wrongful dismissal from work, wills and estate matters, family matters, malicious prosecution, false imprisonment, libel or slander, or allegations of wrongdoing by a judge or justice. Some of the types of matters that could result in a civil suit include contract disputes, insurance disputes, property disputes, disputes over wills and estates, and torts. Torts are civil wrongs that often result in things like personal injury or damage to property. Examples include negligence and malpractice. In a civil suit, the party who alleges the wrong is called the plaintiff, and the person who the claim is against is called the defendant. In a civil case, there is no presumption of innocence. Plaintiffs do not have to prove their case beyond a reasonable doubt. Plaintiffs only have to prove their case on a balance of probabilities, that it is more likely than not. Most cases do not go to trial. It may be possible to compromise or settle a dispute. The possibility of compromise or settlement should always be considered. The use of alternative dispute resolution, or ADR, should be considered. The basic stages in a civil suit are filing and service of pleadings, discovery, pre-trial conference, and trial. Mediation, dispute resolution, or settlement can happen at any time throughout the process. There are also various motions that can happen any time after the filing of pleadings. Pleadings are supposed to accomplish the following: provide notice to the other party of the case to be met, clearly define the issues and narrow them for trial, and create a formal public record of the issues involved. There are many very complicated rules about pleadings. For that reason, a lawyer should draft pleadings. Generally speaking, pleadings should contain a concise statement of the facts, they should not contain evidence, and they should set out what outcome each of the parties is asking for example, monetary compensation or damages. Either party can ask the court to strike out or expunge all or part of a pleading or other document. The reasons for doing this include that the pleadings may prejudice or delay the fair trial of the action, are scandalous, frivolous, or vexatious, are an abuse of the process of the court, or do not disclose a reasonable cause of action or defense. If the civil suit was started by the plaintiff filing a statement of claim, the pleadings consist of a statement of claim, Form 14A, a statement of defense, Form 18A, and in some cases, a reply, Form 25A. To start a civil action or lawsuit, the plaintiff files a statement of claim using Form 14A in the Court of Queen's Bench. The plaintiff then has it served on or delivered to the defendant. The statement of claim sets out who the parties are and a brief description of their relationship, the claim against the defendant, including facts about what happened, the damage or loss incurred as a result, the laws that the plaintiff relies on, what relief the plaintiff is asking the court to award, notice to the defendant explaining that a legal claim has been made against the defendant, how much time the defendant has to file a statement of defense in court, and a brief explanation of how to defend against the proceeding in the court, or how to proceed if they want to pay the claim and don't want to dispute it. There is also a notification to the defendant that if they do not file a defense, that a judgment against the defendant can be made in favor of the plaintiff. Once a defendant receives a statement of claim, they must decide what to do next. This should be done in consultation with a lawyer. The options are: file in court and serve a statement of defense on the plaintiff, make a motion in court to strike out the plaintiff's claim if there are reasons for doing so, attempt settlement either through the plaintiff's lawyers, mediation, or a judicially assisted or alternative dispute resolution process, or agree to pay the claim and court costs. After the defendant files and serves the statement of defense, the plaintiff may file and serve a reply in Form 25A in certain circumstances. A reply should be filed only if the plaintiff intends to prove a version of the facts different from those pleaded in the defendant's defense, unless it has already been pleaded in the statement of claim. This would happen when new facts are raised in the defendant's statement of defense that the original statement of claim did not cover. Discovery is the process of learning about the other party's case and sharing information about your case. In discovery, each side must swear to an affidavit stating what relevant documents and other pieces of evidence they have. The parties must make this evidence available for the other party to examine, unless it falls under an exception of privileged evidence. In discovery, each side's lawyer also conducts interviews with the opposing side's witnesses and parties. This is called an oral examination for discovery. The interviews are recorded and can be used at trial. The following is the typical order of proceedings in a trial. The lawyers make opening statements about their cases. The plaintiff's lawyer goes first. The lawyer for the defendant can make their opening statement after the plaintiff's lawyer or at the start of their case after the lawyer for the plaintiff is finished presenting their whole case. Direct examination of witnesses, reading in of evidence from examinations for discovery, if applicable, cross-examination of witnesses, re-examination of witnesses if new matters were raised in the cross-examination, rebuttal evidence if applicable, closing arguments, and the judgment and awarding of costs. The judge may deliver the decision orally or in a written judgment, or orally in court with a written decision later. Written transcripts of court proceedings are available from the court for a fee, and it is possible to just order the judge's oral reasons for the decision or order. Parties must request a transcript cost estimate before ordering the transcript. You would generally only order a transcript if you were thinking about appealing the decision. A party can ask the court for court costs to be paid by the opposing party, which means covering all or part of the various legal costs associated with the litigation. The costs rarely cover all of the expenses. The judge will assess and has the discretion to award costs, depending on a variety of factors unique to the situation, including the conduct of the parties. The party who is successful at trial often is awarded costs. However, if a party, even the successful one, has caused delays or done things like file frivolous motions, they can be ordered to pay the costs of the other party. Keep in mind that if you get a money judgment, if the other party will not pay, it is up to you to collect. This usually means filing more forms in court. Some collection options include garnishing wages, garnishing bank accounts, having personal property seized, or registering a judgment against land. Also, the unsuccessful party may decide to appeal the decision. For more information, visit these sources. The Court of Queen's Bench rules set out the procedure for civil cases in Manitoba. For small claims, consult the Court of Queen's Bench Small Claims Practices Act. The Limitation of Actions Act sets out how long a party has to start a court proceeding. This varies depending on the type of case. If you would like more information about the civil court process, please visit CLIA's website at communitylegal.mb.ca or call the Law Phone-In and Lawyer Referral Program at 204-943-2305, or if you are outside Winnipeg, toll free at 1-800-262-8800.